First talk.
So when you say it's not the Eurovision Song Contest, does that mean we get votes out of 1 to 10?
That depends on the other lot who have been in it.
Thank you. Okay. Well, good evening, ladies and gentlemen. As Andy said, the subject this evening is health and safety, and I'm the ghost of Christmas past, and Phil is the ghost of Christmas future. So I'm going to be dealing with the first, I'm going to be starting in 2000 BC, with the building of the pyramids, and of course talking here about working at heights, silica, the usual kind of stuff. And then Phil's going to look at the next 2,000 years, starting from today. But just by way of introduction, I think health and safety is in a very interesting place at the moment, and it's largely a consequence of the new government and the economic circumstances. So that really does establish an agenda, or is establishing an agenda, which will take us forward into the future, as Phil will touch upon. But first of all, the past. Is it left click or right click, Andy?
Left. I'll tell you a second and press it, now the other one.
The other left.
Hold on. Sorry.
Shouldn't walk across in front of your presentation.
No, no.
Apologies to the extended audience.
There you go.
All right. Now, oh, this is my history of art presentation. What a mistake. Apologise for that. So I hope everybody can see the picture clearly. Does anybody know what that painting is, by the way? I'll be asking questions throughout the presentation and stuff. It's a painting called Mr. and Mrs. Andrews. It's by Thomas Gainsborough. And what it's intended to say, the actual history of health and safety in the UK is not actually all that old. In terms of the world, health has been an issue for thousands of years, and the effects of lead, the effects of heavy metals have been known for a very long time. But in terms of actual regulation in the UK, it's comparatively recent. If you think about the mid-18th century, prior to the Industrial Revolution, England, the UK, was basically a farming society, or an agrarian society. And there was some 8 million people living in the UK, in England, in 1802. And so in some respects, we're talking about the landed gentry, those with the haves, and the peasants, i.e. you and me, people who actually worked on the land. And that was the way in which the class system operated in the UK at that time. There was no industry, it was simply subsistence farming, with the wealthy taking all the profit, and the tenant farmers and the peasants doing all the work. However,
I'll sit there and push the buttons. Sorry.
we're doing something wrong here. At the start of the Industrial Revolution, and I guess you're talking the late 18th century, then as a consequence of certain events, certain things happened. And the most significant of them, and I think it's fair to say that in the UK the Industrial Revolution essentially kicked off in this part of the world. And with the invention of steam power, then you were able to generate machinery which had the capability eventually of mass production. So during the Industrial Revolution you had the migration from the country to the towns and the cities. And basically, we ended up shifting our focus from the countryside to the towns and the cities. Okay, Andy? So, from a farming society, we had the Industrial Revolution, we had mass production, the growth of towns and cities, and, of course, mass house building. Do you all remember that? Okay. Those in the good old days. In fact, that's a picture of Stoke on Trent, and it just goes to show that, if you recall, for those of you who are fairly local here, it's not that long ago when the city was crammed with large 4-storey manufacturing facilities. And of course, because people didn't have transport in those days, then the terraced houses, the back-to-back terraced houses, had to be built right beside, or as close as possible to the factories, so that people could actually walk to work. And that's why the factories were built up rather than across, simply because they had to pack in as many people to actually fill the factories. Unfortunately, at that time, the employer, most of whom were owner-managers, were interested in one thing and one thing only, and that's really profit. So the whole question of health and safety and the need to protect the worker from the worst effects of machinery and so on and so forth simply was non-existent. But what also came with the growth of factories and the migration from the countryside to the towns was something which was far more pernicious than anything we've seen so far. Okay, because what came with it was child labour, and in many respects that really is what kick-started the whole health and safety agenda here in the UK. And no doubt you'll recall from your school days the history lessons, at least on the Industrial Revolution and the extent to which children were exploited in the mines, in the mills, and in many other factories. Okay. What happened, and this actually, 1802 was the very first health and safety piece of legislation in the UK, and it was basically an attempt to try to protect, albeit in a modest way, and for the first time, the child labourers who were toiling in the mills and actually getting killed and maimed as a consequence. And I think it's rather a fantastic wording of the Act itself. And I'm not quite sure what it exactly means, but an Act for the preservation of the morals of apprentices and others employed in cotton mills and other factories. And of course, apprenticeships are very much the flavour of the month here and now. And no doubt if any of you are employing any, you are protecting their morals. I trust you are at any rate. However, okay, what followed for probably 150 years or so was an enormous swathe of legislation. And what characterised it was fairly piecemeal in nature, so that if a problem was identified, then an act would be passed to address it. It was also very specific. And in fact, the potteries regulations, the potteries themselves as an industry had regulation applying to them specifically, as did many other sectors, including the Bleach and Dye Works Act, whatever that means. However, because it was piecemeal and because it addressed certain sectors or certain industries, whole swathes were not actually covered. So although there was a good deal of activity from the regulator, nevertheless, enormous numbers of people employed in the economy simply had no law to cover them or protect them. The other difficulty was the industrial revolution is characterised by enormous technological advance, and because of that, it was often the case that as soon as legislation was actually enacted, and we all know how long that takes to come about, then the circumstances at the factories had changed. And the other point of it all really was the fact that it was so specific that if, in terms of the actual distance between, say, the guard and the machine, that if your particular circumstance was slightly different from that, then the law no longer catered for you. But the most important aspect, which we really failed to address, was the managers who were saying, okay, the law's the law, if we follow it to the letter, A, B, C, D and E, then we must, by definition, be compliant. And it was therefore the onus was on the regulator to deliver to the employer precisely what it was he needed to do to comply. That's the way in which it was effectively structured. Okay, Andrew? However, by the mid-20th century, the penny dropped. I think it was fairly obvious that the regime that had been in existence for so many years, frankly, wasn't fit for purpose. And the whole thing needed a totally different look. How this different law appeared was by the report by Lord Robbins in 1972, and that was one of his main conclusions, which is quite damning. So apathy is the greatest single contributing factor to accidents at work. This attitude will not be cured so long as people are encouraged to think that health and safety at work can be ensured by an ever-expanding body of legal regulations enforced by an ever-increasing army of inspectors. The primary responsibility for safety at work lies with the people who create and work with the hazards. So that was a template which was established in 1972 by Lord Robbins and his committee. And what, of course, it's saying is that it's the people that create the hazards and the risks that should bear the responsibility for sorting them out. And it's not up to the regulator to simply write regulation after regulation after regulation just to enable the employer to get out from under his responsibility. That was essentially the sea change attitude, and it didn't take them long enough to come to that conclusion, but in any event, that's how it came about. So the Health and Safety at Work Act of 1974 was essentially the template with which we still operate. Okay? So, principal characteristics. It established the Health and Safety Executive, it established the Health and Safety Commission, and it was tripartite in nature, which basically meant that the employers, the Health and Safety Executive, and the trades unions really had to begin to pull together to achieve the common goal and continuous improvements. And also, because the Health and Safety at Work Act was essentially an enabling act, and what followed was guidance, approved codes of practice, and any enormous volumes of help to enable the employer to comply. Not everybody agrees that the Health and Safety at Work Act has actually done the job that was intended of it. You think back to 1974 and what industrial relations was like in the mid-1970s, then you can't fail but come to the conclusion that it was very much an adversarial climate. And I do recall the automotive industry in the 1970s and read Robbo, and the extent to which, therefore, Lord Robbins could actually expect the trades unions to work collaboratively and cooperatively with the employers. Industrial relations climate, one might argue, simply wasn't conducive to a collaborative, joined-up effort. And in some respects, and are there any trades unions officials here this evening? In that case, I feel comfortable in what I'm about to say. Basically, if you're going back to the beginning of the 20th century when trades unions was first established, they were established to take on employers and to try to improve industrial relations and the lot of the worker in the factories. It was an adversarial relationship, basically. And they devoted themselves, A, to fighting the employers in terms of disputes, but also negotiating with employers to improve terms and conditions of employment and, of course, pay. They were not set up to become involved and play their part in health and safety, because they simply felt that health and safety was the responsibility of the employer, and they were fearful of getting involved for fear of being compromised, being party to a decision, and then that decision going badly wrong. So in some respects, the ambition of Lord Robbins, one could argue, was too great for the times. And that, I think, in a certain sense, has impeded progress. The other point to bear in mind is that enforcement under the previous system, you either were getting it right or you were getting it wrong. And if you were getting it wrong, then you were in court. The Health and Safety at Work Act enabled a variety of different enforcement interventions to take place by the Health and Safety Executive. So you would have prosecution perhaps, or more importantly, an improvement notice. So there was a degree of flexibility there which would help encourage the employers to actually do the job that they were there to do in terms of health and safety, to fulfill their responsibilities, and it was very much a team effort. And I think that's been one of the great strengths of the Health and Safety Executive over the many years. Okay? What also came to the Health and Safety at Work Act were some rather interesting phrases, which in some respects help, but in others actually make life slightly more difficult. We have all seen the terms reasonably practical, practicable, sufficient, and competent, and I'm not going to attempt to define those now, but they are essentially words that the employer needs to interpret based on the degree of risk that he or she is actually addressing. And what actually ends up being sufficient will depend upon the risk that is being examined. Okay. Now, I mentioned earlier on that the Health and Safety at Work Act has been the bedrock of health and safety for the last 30 years or so. 25 years after it was enacted, John Prescott got hold of it, felt that it was becoming tired and needed a bit of a shot in the arm, and what he did was to write a report called The Revitalising of Health and Safety, which established targets for the very first time in the field of health and safety. The ceramics industry, along with other sectors, agreed with the Health and Safety Executive to establish a sector programme of work called Ceramic Industry Health and Safety Pledge, which actually was 10 years old last year. And the whole point of the exercise was to reinforce the collaborative effort with unions, employers and the Health and Safety Executive, and to roll out a programme of work which would again improve matters, hopefully even more so than they had in recent years. And in many respects, initiatives such as the Pledge will still form a very considerable part of the health and safety landscape moving forward. Because as my colleague Phil will tell you, HSE's resource always stretched even more, and in order for things to continue to improve, then industries such as the ceramics industry has to pull together even more in order to make matters better. And that is exactly what the Pledge is doing, and that is exactly what the Pledge Board is determined to continue its work with. So, ladies and gentlemen, that's a thumbnail sketch of how we got to where we are, starting with the Industrial Revolution and the dreadful conditions that people were expected to work in, the situation now where we have genuine collaboration with excellent cooperation from the trades unions and the Health and Safety Executive, and continued determination to improve matters moving forward. That's the past, here's the future.
Good evening. I'd like to start by expressing my gratitude to Keith Morton, who will be known to all of you, hopefully, for my appearing before you tonight. Now, Keith was an influential member of one of HSE's advisory committees, and when I say that he's a true leader, I actually mean that he was a true leader in health and safety, and very supportive of what HSE did. He used to come to these meetings and he would willingly volunteer to support activities, volunteer the efforts of IBSTOC to the industry at large. Sometimes he actually willingly volunteered without actually knowing that he'd done so. And
Numerous times.
yeah, numerous times.
Well, I wasn't even there.
And so he's got his own back because he volunteered me for this tonight. And another peculiar aspect of tonight's presentation is that I went away on holiday last November with one title in my mind and came back from holiday at the end of November to be confronted by a totally different title. So what you are going to hear about tonight is my take on what I think will happen to the health and safety system in GB, because there's a separate system that applies to Northern Ireland. What will happen in the near to middle future. Now Francis has helpfully covered the first 300 to 400 years in the space of 20 minutes, and I hope to cover about 4 years in at the same length of time. I apologise that some of it's a bit heavy going, but I think it's helpful if you know how we come to be where we are and what this means for going forwards. And these are the topics that I hope to go through, and if you look at that list you'll see frequent references to review, and in the past few years that's what HSE has been subjected to. The views I express are personal views, not necessarily endorsed by HSE or representing HSE's views, so I'll predicate what I'm going to say by making that announcement. And I want to start in June 2009. In June 2009, HSE launched its new strategy for the health and safety system of Great Britain. Judith Hackett, who some of you may have heard speak or may be aware of, joined HSE in 2007 as chair of the Health and Safety Commission. Those two bodies, the Health and Safety Commission and the Health and Safety Executive, were merged in 2008, and one of the first things that the new board did was generate a strategy. And this runs through a lot of what I'm going to say and is actually very important for how we take things forward in the future. So we just need to be cognizant of these kind of things. And the strategy covered certain key goals. I haven't listed them all there, but I've listed the most important ones, or the most important ones I think that are relevant to you this evening. And those key goals were, in terms of strong leadership, things aren't going to happen unless it's led from the top by people like CEOs and MDs, boards. The need for building competence. We can't move forward unless we have management and workforce that are competent in the area of health and safety, so that they can recognise the hazards and risks which exist in their workplace and come up with solutions to deal with them. Workforce involvement, I think it probably goes without saying, or hopefully it does, that the best way of moving forward is to work with other people, the workforce. And studies that have been carried out by HSE demonstrate that where there is active workforce involvement, good pragmatic solutions are developed for problems that arise, and things move forward. The performance of companies where there is active health and workforce involvement tends to be better than those where it doesn't exist. When the strategy was launched, in the year before, 229 people had been killed, over 136,000 people had been seriously injured, and 2.1 million people were suffering from a work-related illness. So it goes without saying, there is a need to create healthier and safer workplaces. And to enable that to take place, there are certain parts of industry that need help, especially small and medium-sized enterprises and micro businesses, because in those kind of businesses they're the master of everything, and they need help in knowing how to tackle the health and safety problems that affect their businesses. And lastly, but one that probably doesn't impact too much on yourselves, is the avoiding of catastrophe. We'll all remember Buncefield a few years ago. Some of us may remember the repercussions of Aberfan a long time ago. Those are the kind of things which we mean when we're talking about avoiding catastrophe for high hazard industries. These are events which don't take place all that often, but when they do, they have a serious impact, and not only to the workforce. So those are the key elements of the strategy that perhaps we can just bear in mind. I now want to move forward, great leap of 1 year to 2010. And we get a new government, a coalition government in place, and one of the first things they do is think about how to tackle the financial crisis. They have a June budget, and they set up a spending review called SR10, Spending Review 2010. That's a Treasury-led process, as you probably know. It's designed to allocate resources across all government departments according to the government priorities, and health and safety was not a government priority, and that's reflected in the fact that HSE suffered a 35% budget cut announced in the budget, and over a period of 5 years taking us up to 2015, and that didn't apply just to HSE. Other government departments were affected by a similar cut. It's worth pointing out that at that time that cut was made, not all of HSE's money came from government. About a third of it comes from what's called cost recovery, where they charge for things, particularly in major hazard industries, where our major hazard people will charge for reviewing safety cases and site visits, nuclear industry and offshore industries. So HSE was getting about a third of its money from that kind of activity, 2/3 came from government, and that was going to be slashed by 35%. That's a significant reduction. So what did HSE do? What was their response? Well, it looked at opportunities for making efficiencies, making savings. This is part of normal business, doing it all the time. It looked at better ways of working. It cut the government, the estate, closed some offices in some places, relocated to out-of-town locations because it's cheaper. Instead of having an office in the middle of Birmingham, it's cheaper if it's near the M5, outside of Birmingham. That's just the reality of the world. One other thing it did was, in a 2 to 3 month period, January through to the end of February, starting in December 2010, by the end of February 2011, there were 200 less people employed by HSE as part of cost savings through redundancy. It was voluntary redundancy, but nevertheless the posts went. Now, the Minister actually asked HSE to look at ways of replacing government funding from other sources. I'll come back to that a bit at the end, because it does affect those of you who are still working in the outside world, which I hope not to be in the too distant future. They started off by closing things like Infoline. I don't know whether any of you have used Infoline, heard of Infoline. Well, it was closed down. It was a free telephone advisory service that people could ring up and get free advice on general health and safety matters. Closed. It closed the Incident Contact Centre, where employers used to report accidents that were then passed on to HSE. It was based in Caerphilly. That was closed down. They were contracted out services. It represented a saving. In terms of reporting accidents, you now report them online, or if it's a fatal, you report them through Job Centre Plus. The HSE website was updated, and all individuals' names that used to appear on there, together with addresses and contact details, were removed. So the opportunity for you to go and pick up the phone and speak to your local friendly inspector, unless you cast his number or her number or email address to memory, was erased, simply because HSE didn't want everybody replacing Infoline by ringing up their local inspector and asking the questions, because that would just bog inspectors down. So this is how cost saving started to come in. Now, in addition to the budget cut, the Prime Minister asked Lord Young, I think we don't refer much to Lord Young now, but at the time we did, Lord Young to carry out a review. And he asked him to carry out a review on the operation of health and safety laws and the growth of the compensation culture. And Lord Young produced his report in October 2010 called Common Sense, Common Safety. It basically covered a number of areas where the received wisdom was that there was colossal costs being imposed on industry associated with this health and safety culture that had developed. The thing like no win, no fee compensation, the requirements of insurers that made employers really operate under a climate of fear. Lord Young acknowledged that HSE had a role to play in promoting a common sense approach to health and safety, ensuring low risk businesses especially could function in a way in which they were not burdened by this colossal amount of red tape health and safety legislation. And Lord Young's report contained 17 recommendations for HSE to pursue. He wanted simple risk assessment processes to be put in place, checklists. He wanted an interactive assessment tool to be on the web that people could use to help them with risk assessments. He wanted simple guidance. He wanted safety consultants to come under the auspices of professional bodies and have professional qualifications. He wanted HSE to set up a directory of such consultants that people could go to, so that they knew, well, that person's on the list, we can go to him with some idea that they meet a certain basic standard. He also wanted a procedure to be put into place whereby people could challenge the views of officials. Indeed, we now have launched, I think only a few months ago, it might have been January, the Independent Regulatory Challenge Panel. So if, as a business, you think that an inspector has given you unreasonable or disproportionate advice and you want to challenge that, you can do so initially through line management, but if you don't get anywhere with line management, you can go to the Independent Regulatory Challenge Panel and ask them to review it for you. The current panel deals with the activities of regulators, that's ourselves and the local authority who enforce in low risk premises such as offices and shops. There will be a second challenge panel set up during the course of this year which enables people to challenge the advice that they get from non-regulators like the insurance industry. In addition to all that, Young suggested that health and safety legislation needed to be made simpler. His idea was that it should be consolidated into a single set of accessible and easily understood regulations. Well, that's back to the Health and Safety at Work Act, really. But he also went on to say that at EU level, we must ensure that directives do not give rise to prescriptive or disproportionate rules, because a lot of stuff comes from Europe. The systems that they have for putting that into operation are different to the systems that we have, and when we transpose a directive into national legislation, we then have an enforcement mechanism which attempts to ensure that people comply with it. The same doesn't happen necessarily on our continent with our continental colleagues. And lastly, a very strange but specific thing was the change to the reporting of injuries, diseases and dangerous occurrences regulations, because Lord Young wanted the current situation where you report over 3-day injuries to HSE or the local authority as appropriate. He wanted that changed to reporting to over 7-day injuries to bring it into line with the Fit for Work notes procedure that GPs operate. And he saw this as removing a burden by making the two work in parallel. That actually comes into force, into operation on the 6th of April this year. So as from the 6th of April, you will be reporting over 7 days rather than over 3 days, although I hasten to add you still do need to maintain a record the injuries that occur, whether it results in an over 7-day loss or not. Now, I now want to move forward to March of last year. So we've had the Lord Young report, and then on the 21st of March, our Minister, Christopher Grayling, makes a ministerial announcement in the form of good health and safety, good for everyone. This is worth spending a few minutes of your time just going on to the website, and I've given the web address, I'm sure the presentation will be circulated, just having a look at what this says, because this is the main driver for what HSE will be doing in the future, well certainly up to 2015. One of the things to come out of all these changes is that HSE's work up until 2015 will be driven by what are called sector strategies. The one that covers the heavy clay industry is the manufacturing sector strategy, and that embodies what our Minister has put in this publication. That's built into the sector strategy, and that drives the work forward. These sector strategies are or will be available on the website for everybody to look at, probably in the first quarter of our new work year from April onwards. So you'll be able to see exactly what these sector strategies require, and hopefully be able to see where your industry fits into them. I'd like to pick out 4 elements from our ministerial announcement. The first is, I mentioned that Lord Young wanted a web-based directory set up of consultants, and there is one. The Occupational Safety and Health Consultants Register, which is available online, where you can go and find a consultant, and you can search using a number of filters. I mentioned that Lord Young wanted things made simpler, and so HSE has produced Health and Safety Made Simple. It explains in plain English what people need to do to comply with the basic requirements of law, of the health and safety law. I mentioned that Lord Young said there needed to be a review of regulation. There are 2 separate reviews of regulation, which I'll mention in a minute. It's currently dealing with the review of all the health and safety law that we have. And the ministerial announcement also introduced the new health and safety framework. Now this is fundamental to what HSE will be doing, because there are a number of elements in there. I picked out 3. Joint working with industry. France has helpfully mentioned about the Pledge Initiative, which is a partnership piece of work with the regulator working in cooperation with industry. The Pledge one is set up on tripartite grounds. They're not all, there are a number of them in progress. But basically, joint working with industry was to be encouraged. Build on the initiatives that we have, use them to secure better health and safety and pass on good practice by way of sharing information. A reduction in inspections. Now, this might be good news to you, I don't know. HSE carries out about 33,000 inspections a year. In the ministerial announcement, they were to be reduced by 1/3 to 22,000, so less proactive inspections. Cost recovery. I'll come back to the difficult issue of cost recovery a little bit further into the talk. That's the bit where your eyes may prick up if you're representing employers who might be subject to cost recovery. One of the reviews of the law was done by Professor Lofsted of King's College London. His remit was to look at reducing the burden of business through combining, simplifying or reducing the amount of health and safety law that existed. And that extended to looking at approved codes of practice, which are quasi-legal documents. They give guidance on how to comply with the law, as you probably know. You don't have to follow their requirements. They're a bit like the highway code. They tell you how to comply. If you don't follow their requirements, you can achieve compliance with the law in an equally effective way, but the onus of proof is on the duty holder to show that they've done so. So they're quite influential documents. And so the Lofsted Review was looking at the law and the ACOPs as they're known. And Lofsted came up with a number of recommendations which included exempting the self-employed from the application of health and safety law, except in those situations where what they did affects the safety or health of other people. Otherwise, he said, shouldn't apply to them. Reviewing all 53 ACOPs. Now the timescale for this is quite generous, June this year. And consolidating the law, which means going through all the health and safety legislation that we have in an attempt to simplify and streamline it and strip out things which are just unnecessary burdens on the duty holders, and that's entirely laudable. He recommended that enforcement activities should be focused on the most risky businesses, so our inspection plans now focus on higher risk industries and leave the lower risk ones alone. And there's also a big issue about improving consistency. We have a big enough problem of ensuring consistency, as I'm sure Francis will testify, within HSE. Ensuring consistency between what HSE does and what the local authority sector does is a nightmare. And so Lofsted was saying you need to get your act together and you need to ensure consistency so that the poor old employer out there knows what they should be doing, basically, in a consistent way. And Lofsted also said we need to work more closely with the European Union. He was saying that any new directives and any that are coming up for review, and there's a major review of health and safety directives, I think either planned for this year or next, these reviews, any new directives, should be evidence-based. There should be evidence that the requirement is needed based on actual risk. We shouldn't be flying kites, and we must ensure that when we transpose those into national legislation, there is no gold plating. It's not added to. The received wisdom is that HSE, on behalf of the UK government, when it gets a new directive, adds things to it. I think probably there are examples of that. Equally, we're being challenged by the European Commission at this moment over a directive that we failed to implement fully, so it works in both ways. Now, running in parallel to all that was the red tape challenge. Now, you may have heard of the red tape challenge. This doesn't apply to HSE. It's across all government, across all legal requirements, and it's a public consultation process. It's a web-based consultation. Health and safety legislation was up for this consultation in June, July last year, so unfortunately you've lost your chance if you wanted to comment now. But it meant that public and businesses could comment on the law that applied to them and make their suggestions. In fact, the comments that I saw on health and safety legislation, there weren't very many of them, and the ones that I saw were quite supportive of the existing regime. For a lot of people, it didn't seem to cause a problem. I don't think I saw any comments which was totally hostile. The idea of this is to eliminate avoidable burdens. The government also laid down through this, by virtue of this process, that if government wanted to bring in new legislation, an equivalent burden had to be removed by getting rid of a piece of existing legislation. That's an equivalent burden in terms of its impact cost burden on industry. So now we can't introduce anything unless we get rid of something of an equivalent impact on industry. And all new law has to include a sunset clause. Now this will be quite interesting because what it means, typically these sunset clauses require the removal automatically from the statute book of a piece of legislation after a 7-year period unless there is it's actively kept on the statute book. So if you can think, there's a piece of law that comes into force in 7 years' time, it will just drop off the statute book unless someone has the foresight to actually say, we still need this. This has had an interesting repercussion in one example that I'm familiar with. I don't think it's in the health and safety arena, where something dropped off the statute book and no one realised that it did, which creates a bit of a problem if you get into an enforcement situation because you're trying to enforce a piece of law that no longer exists. Again, the red tape challenge made this recommendation: remove gold plating. Now, as you can appreciate, there's quite a bit of health and safety legislation that's being looked at by HSE at the moment, as each lot comes up for change or removal, there's consultation processes through public consultation. There's a consultative document out, I think, on the first tranche of 7 sets of regulations that are being suggested for revocation at the moment. But as well as that going on, HSE, to make its guidance simpler, which was a requirement of the Young Review, is reviewing and revising all its guidance. Now, I don't know whether you've looked at the health and safety HSE web pages, get an idea of how many hundreds of web pages there are. There's something in the order of, I think it's 1,600 publications. There's a plethora of instructions that are issued to inspectors, the internal guidance. All this is also being reviewed at the same time and revised with the intention of making it simpler, removing gold plating requirements, telling people this is what you need to do to comply with the law, and removing duplication, trying to ensure consistency so that if you look at one piece of HSE guidance, say on risk assessment, it gives you the same advice as if you look at another piece. And currently I have to confess that that's not always the case at the moment. Again, generous timescale for getting all this done. I said that the ACOTs were to be reviewed by June, I think it was, this year. This lot's got to be done by August, so we've got a bit longer to do that. I don't know whether the world will stop rotating when it's not done. I don't think that target will be met. It certainly won't be met by my team's review of the guidance it's got to deal with, because there's so much of it. And there's one person on my team who's dealing with most of it. So if he's dealing with the law, he's not dealing with the review of the guidance. But we will do our best. Now, if you haven't been listening to the last lot, fine, you might want to listen to this bit, because this is an interesting bit, because from the 6th of April, if all the problems have been ironed out, and someone can decide whether cost recovery is a fee or a tax, and that's decided by the National Audit Office. If it's a tax, the money goes to the Treasury, and you need primary legislation to enact it. If it's a fee, then it can be done by the amendment to the Health and Safety Fees Regulations. But it's supposed to be coming in, I shouldn't have told you that, by the way. It's supposed to be coming in on the 6th of April, and there are certain things to note about this. The philosophy, I think, is probably sound in that it works on the principle that a business which is in material breach of the law should pay for the inspector, the regulator's time in putting that right, rather than the public purse. So that's an area of debate. It was thought that that might also provide an incentive to people who don't comply with the law at the moment. If they thought they were going to get charged if they were found out not complying with the law, that's in addition to any court action that might take place. If they thought they were going to get charged for just an inspector turning up, then they might put their house in order to avoid such charges. So it levels the playing field. Now, it's a recovery of cost for material breach, and it runs at £124 an hour. I think if a prosecution's involved, the current rate is about 67 quid an hour, so nearly double for this. And basically, inspector finds material breach and will charge for effectively the time spent in getting that breach put right. Now here's the little nuance. Let's say the inspector walks across the threshold at 10 o'clock in the morning, and let's say at 12:30 they turn the corner, they see an unguarded machine, and they say, material breach, you need to put that right, I'm going to charge you for this. The charging starts from the time that the inspector stepped over the threshold of the factory or the site. Starts at 10 o'clock, not 12:30 when they found the breach. And it continues until the breach is put right, so that might mean further visits, it might mean the inspector serving notices, it might mean the inspector consulting other colleagues in HSE, and that will all be charged for at this rate of £124 per hour of those individuals' time. I think you can start to see how it might add up if something is found wrong. So as a colleague of mine said at an advisory committee meeting, it's best to get your notices in before the 6th of April, basically. It'll cost you a lot afterwards. That's if it goes ahead, but we're working on the assumption that it is. Now, you're probably wondering, what is a material breach? A material breach is if, in the opinion of the inspector, there's been a contravention of health and safety law that requires them to tell the employer, the duty holder, you need to put it right because I think you're in breach of the law. The sting in the tail is, what do we mean by in writing? Well, in writing apparently means, well, if they start to collect evidence for prosecution, if they issue enforcement notices, if they write a letter, if they issue an instant visit report, which is where they don't write a letter, they fill out a form actually when they're on the site and leave it with the employer. Or even if they send an email. So if they send an email confirming something to the duty holder in writing, that will be a material breach subject to cost recovery. That's the downside. How much income that will generate, I'm not sure anyone knows, but presumably someone's tried to have a look at the sums. But I want to leave you on a high note, because it's been a bit of doom and gloom so far. And the note I want to leave you with is, in the ministerial announcement, there was reference to this joint working initiatives. The BCC's pledge is one of a number of such initiatives that are in operation in the industries that I deal with. I think there's about 8 that my team cover. And basically, they were put into place, as Francis said, to deliver the revitalising health and safety targets set by Prescott back in 2000. And the BCC Pledge Initiative, for those that you know anything about it, has all those elements of the strategy that I referred to: leadership, building competence, workforce involvement, creating healthier and safer workplaces. It's got action plans and targets, providing guidance. Francis has been particularly instrumental in producing toolkits to help SMEs actually comply with the law. Not guidance, a thing that enables them to actually do something and deliver the right result. And so the BCC Pledge one illustrates all these kind of features of targeted initiatives. These targeted initiatives, through some research carried out by HSE in 2006-2007, actually that research shows they do deliver measurable health and safety improvements. They're a vehicle, a way in which others, like trade associations, like professional institutions such as those that you belong to support the delivery of such improvements. They apparently have a greater effect on health and safety management than on culture. What we want to change is safety culture, but the first step on the route to doing that is to actually change management. And a reduction in injuries which can be greater than the target set by government. The initiatives that I deal with have all generated a performance that exceeds the government set targets. So they're a good news story, I think. You won't be able to see the figures. I don't think it's important that you do see the figures. What's important is just to note the trends. These are 4 examples from the foundry industry, the quarry industry, the cement and the concrete industries. The best performing have delivered over a 10-year period 86%, over an 86% reduction in the number of reportable injuries, that's reportable to HSE, over a 10-year period. That is a phenomenal improvement, to my way of thinking. And the pledge is no exception. Downward trend has delivered over a 77% reduction in injury rate up to from 2001 to 2009. So they're a good news story. I think they're a good news story. As a consequence, I think I want to finish with this note. Francis mentioned Lord Robins' 1974 Act, the concept of self-regulation. And I think these initiatives actually do demonstrate that industry sectors, with the right leadership, the right motivation, can go a long way along that road to self-regulation. The conclusion of the research workers was there was evidence that partnership-based targeted initiatives, such as the pledge, can achieve significant improvements in health and safety. Injury rates declining faster after schemes start. Injury rates better than for the manufacturing sector as a whole. So irrespective of what else might be going on in HSE, in terms of reduced staffing, reduced resources, the need for more targeting on higher risk industries, I think that what these initiatives show is that for some industries, and I think ceramics and heavy clay industry falls into that category, this is a route whereby working in partnership with the regulator, with HSE, significant improvements can be achieved with not a great deal of input from HSE necessarily, but a great deal of input from industry. And on that note, I'd like to thank you for listening, and we'll have a go.
Do we have any questions? Yes.
I have a question. Do you feel that your counterparts in the European Union are operating on the same wavelength, the same guidelines as yourself? We talk about the reduction of red tape in industry and getting clear pathways for industry. But on health and safety, when I was working, certainly some of our European partners, factories that I visited, were extraordinarily dangerous, and yet we're trying to compete with them. Do you have counterparts operating the same compliance in the European Union?
That's a bit of a difficult question for me to answer because I don't know enough about the enforcement regimes that exist in different parts of Europe. There's the European Health and Safety Agency, which is intended to try and ensure a greater degree of consistency. There's the Senior Labour Inspectors Conference, which meets to discuss these kind of things. The way in which they work, from my limited understanding, is different from our legal systems and the way that we work over here. And I think, you know, sort of, if you think back over the years, one of the problems that we have faced is that we portrayed as a nation of being, you know, sort of obstructive and difficult when it comes to negotiation over things in Europe. But we have a pragmatic approach to it. We want things that are going to work, as opposed to some of our European counterparts who are quite happy with the goals and the aims, but then don't do much to ensure that it actually takes place on the ground. Whereas we have enforcement mechanisms. I mean, I think all EU states have enforcement agencies. But as someone said to me when I was in Greece once, you know, Greece apparently have got over 2,000 inspectors, but no one's ever seen one. So in terms of, you know, sort of the numbers on the books, yes, but when I was over there, you know, sort of just looking at agricultural machinery, they had PTOs, which over here would require to be guarded, that were sort of 12 feet long, totally unguarded with people working there. I'm not sure that I can answer your question. I think what we've tried to do And certainly when I was involved with going over there to deal with directives in a very limited capacity, it was to actually try and get something that was workable, as opposed to sort of airy-fairy, which they see some of our European counterparts seem more content with. But having got it on the statute book, we will do something about it because that's the way that we are. I'm not sure that they all go over there, and there might be an issue there. Certainly 20 years ago when I was involved in some European stuff, a group was set up, which I was part, which was looking specifically at the different strategies of the different enforcing authorities to control of chemicals in the workplace, in an attempt to achieve consistency. But there's a big issue that our industry may be bearing a cost that our European counterparts aren't, but are still subject to the same law. And I don't have the answer, really. I'm sure that it's talked about how to ensure consistency. But yeah, I think that sort of there are differences inevitably, and I think there's a big issue probably about our Eastern European colleagues who have joined the EU recently, because they've got, in some ways, more to catch up.
I'll tell you next week.
Refer to a breach. Whose breach is it? For instance, if you had an oxyacetylene welder who didn't put his goggles on, or didn't wear safety boots and he damaged his feet, is it the worker's breach and he's responsible, or is it the employer's breach for seeing that he didn't do it?
Well, the employee has a duty under the Health and Safety at Work Act, Section 7, to comply with the requirements of their employer with regards to health and safety, and to ensure that what they do doesn't endanger themselves or other people who might be affected by their work activity. But the primary duty in health and safety legislation is on the employer. So, if someone had an injury, and let's say they had a foot injury, and wearing safety footwear might have mitigated that injury, I think an inspector would probably say, well, right, what are the procedures in place? Was the individual provided with safety footwear that was appropriate and suitable for them to comply with the personal protective equipment regulations? And what steps did the employer take to ensure that that footwear was worn? Now, if I can give you a concrete example, when I used to inspect the pottery industry too many years ago for me to want to remember, it was quite common to go around and find people not wearing their ceramic terraline protective clothing because it's uncomfortable. And it depended on whether the employer had got processes in place to ensure that protective clothing was provided, maintained, and they had supervisory procedures in place to do as best as they could to ensure that it was worn. So I can remember going into factories owned by some of the larger employers in the area, where they had processes, policies and procedures in place, and where they could demonstrate to me, look, this is what we've done, and short of disciplining the individual, this is where we're at with it. They simply refuse to wear the protective clothing, in which case I would probably knock out a letter to the individual concerned saying, reminding them of their Section 7 duties, and they render themselves liable to prosecution. I think increasingly there has been a bit of a focus on trying to. Most employers have processes and procedures in place these days to try and ensure that employees actually toe the line and do what they should be doing. But if an employer, from my point of view, and I'm speaking personally, if an employer has done all that they reasonably practically could, short of sacking the individual, and I am aware that in some industries individuals have been sacked for persistent breach of company rules, I think focus would turn to what is the employee doing. But I think you always start off looking at what the employer has done. And if the employer's discharged their duty, in my mind, you then shift your focus as to why is the employee not doing it? What is the reason? Are they just being difficult? Is there a real problem? I can remember some individual who had real problems with wearing ceramic terylene overalls, and I said to the company, they said they couldn't actually get him to do it because he kept saying it was uncomfortable and caused rashes. And I said, well, you need to provide evidence, medical evidence, that is in fact the case, and that they did. And we explored the way in which they could comply with their duty in some other way.
Duty holder or employer felt that an inspector had been unduly harsh in his interpretation of a material breach. At what point can he go to this newly created challenge panel, and does the cost recovery clock stop ticking at that point, which I somehow doubt?
You're not silly.
I don't understand what the challenge panel is, I should say.
Sorry?
I don't really understand what the challenge panel is.
Well, what it's there's a couple of people from HSE who sit on, well, they're not employed by HSE now, they're ex-HSE, so they bring sort of professional expertise, and then there's some independents sit on it. It's chaired by an independent person. I can't remember who it is, but I think the idea is that if someone goes in and says, I'm an inspector and I think you should be doing A, B and C, and the person looks at the legislation and thinks, well, that can never be right, it provides them with an opportunity to actually challenge that by saying, we think the inspector has been disproportionate in what they're asking, and it provides a route for doing so. But I think you would exhaust going through probably line management. I mean, typically what would happen, within my experience, if someone actually had a problem with an inspector, they'd ring the inspector's boss up, who would be a senior inspector, and say, your inspector's asked us to do this, and we don't think that's quite right, is it? And then the more senior inspector should look at that objectively and come up with an answer. Now, if you aren't satisfied with that, I think the independent challenge panel provides an opportunity to seek redress through this independent mechanism. And I can provide you with a copy of the press release and references so that you can find out more about it if you want. The cost recovery has an appeals system built into it, which is separate from that, so I understand. It started off that if someone was aggrieved about being charged for a material breach, which they didn't think was a material breach, they could appeal to the inspector's line manager, and if they weren't happy with that, they could appeal to that inspector's, the more senior inspector's line manager. This smacks of DVLA sort of making, do you remember there was a case in the paper where sort of, the DVLA were acting as judge and jury basically, and it was the same sort of thing. Basically you're appealing to someone who's part of the system, which doesn't sound too bright to my way of thinking. So they've now introduced an independency to the appeals through the cost recovery route. Fortunately for me, I'm not involved in the cost recovery. I don't have to do it. My colleagues do, who work on the sector. But I can't tell you off the top of my head whether the clock stops ticking while the appeal is considered. You're shaking your head. So what you're suggesting...
I doubt it. Otherwise everybody would appeal.
What you're suggesting to me, I think the mechanism might be, if you appeal and the appeal's upheld, obviously you wouldn't be subject to cost recovery. If you appeal and the appeal is rejected, I think you cop the lot for the appeal process as well. I can check that out for you if you want, but it is all on the HSE, or will be on the HSE website, to find out. But to be fair, HSE did carry out a public consultation, not on whether cost recovery was going to take place, but the actual process. And they listened to people, and people said, we're not happy with this appeals procedure that you've put in place. And so they did change their mind and introduced an independent element. But I think that is a slightly separate process from the independent challenge panel, I think. Because one's to do with sort of breaches, basically.
Yeah, we're here. Yeah.
Any questions from you?
Questions? I've very much enjoyed the presentation, but we've got no questions. I think we did the answer quite well.
Okay, thank you very much. Over to West Yorkshire then.
Good evening, everyone.
Good evening, Chris.
Good evening.
One question from West Yorkshire.
Throughout the presentation, you mentioned giving advice to SMEs. Could you just tell me what SME is? Thank you.
Can you say that again, Chris?
We've answered the question. The question was, could somebody give a definition of SME?
Oh,
All right.
small and medium-sized enterprises. I think a medium-sized enterprise goes up to about, is it 250? Isn't it?
250.
Yeah. So if you employ up to 250, you'd be counted as an SME.
Okay, that concludes the voting from West Yorkshire.
Thank you, Katie. Thank you very much. Over to Notts and Derby.
Notts and Derby calling. More feedback. I don't think we've got any questions. But thank you very much to the speakers
Okay,
and for the organisation.
Thank you very much. And finally, London and home counties.
Good evening all. This is from London and home counties, but thank you very much for the presentation.
Okay, thank you very much, Neil. Finally, any further questions from Stoke? Right. Okay, thank you very much.